Welcome back to Organized. I'm Professor Seth C. Oranburg, and we're continuing with shareholder litigation. In our first episode of this season, we laid the groundwork by explaining shareholder litigation as the mechanism for holding company leaders accountable. And we introduced two main types of suits, direct and derivative. Today, we're going to deep dive into those distinctions and explore the critical procedural requirements of standing and demand. These aren't just rules. They're designed to ensure only legitimate claims move forward. So we balance shareholder rights with company efficiency. At its core, this is about addressing the agency problem. Shareholders, as principals, delegate control to managers as agents, but agents might act self-interestedly, creating costs that litigation helps mitigate by aligning incentives and enforcing accountability. But there's another factor as well, which is that shareholders are not a monolith, and they may have different interests. Sometimes their interests are not aligned with the companies as a whole either. So we have a number of different safeguards that law has created, and we're going to learn about some of them today. A direct action is where a shareholder sues for harm that's personal to them. It's where something affects a shareholder's individual rights or their shares directly. For example, if a company issues a press release saying, "Our new product is a huge success," but it's actually a flop and they knew it, that's a misstatement. A shareholder might buy the stock because of this statement, and that's reliance on a material misstatement. And that's harm to a particular individual. The harm is to the shareholder specifically. The shareholder was misled, the shareholder lost money. So the shareholder can sue the company or its leaders to recover for the loss. It's direct because the injury is straight to the shareholder. It's not filtered through the company. And this will make more sense when we talk about its contrast, the derivative litigation. To make this more relatable, you could think about maybe buying a concert ticket based on ads, promising that you're going to get a full show, but the band only plays one song. You could sue for your bad experience. The recovery should go to you, the plaintiff. And these claims are often based on securities laws that protect investors from fraud or misrepresentation. So, to learn more about direct actions, tune in for our series on securities regulation. And contrast that with a derivative action. A derivative action is where the harm is to the entire company, which indirectly affects all the shareholders, including, if you've bought the stock, you. The shareholder, though, isn't suing for just their own pocketbook. They're suing on behalf of the corporation to fix a problem the leaders caused or ignored. And those problems are usually grounded in fiduciary duties. So here, if you want to understand derivative actions, the substance of it is in our lesson on corporate governance, because the directors owe duties to the corporation itself, and the corporation could sue them. For example, if directors approve a merger where they pay way too much for another company because the target company's CEO is a friend who gives them kickbacks, that's a waste of corporate assets, and it's a breach of the duty of loyalty. And it dilutes the value of everyone's shares, but the company is the real victim. However, the board's not going to sue themselves. So, how do we solve this agency problem? The shareholder, in an unusual maneuver, steps in and causes the company to act, which again is odd because one of the fundamental characteristics of corporations is the separation between ownership and control. This is a breach of that general principle where the owners exert control as derivative plaintiffs. They derive their right from the company's injury. Now, importantly, in a derivative suit where we have a breach of the duties of managers to the company itself, the money or the remedy actually goes back to the company. We might rescind the deal, which benefits the company, or we might get recovery, and that goes to the company's treasury. Now, this should benefit all shareholders proportionally, and the lawyer might get a legal fee, but this is a fundamentally different kind of litigation where we are worried about the harm to the company, and it's based in the fiduciary duties that we learned about in corporate governance. It also has an important stopgap because we have to generally ask the corporation's board to take actions. And we have safeguards to prevent these from being abused because derivative actions are powerful for addressing agency costs, but they also have risks of shareholders trying to get the company to do its own bidding, which is its own set of problems. Again, the distinction between direct and derivative drives the entire lawsuit. In a direct action, You don't have to worry about asking the board for permission because you're making a personal claim. Instead, you have to prove with material information that you were represented against and harmed. So it's a different set of facts, often based on securities laws that give you grounds for suit. Derivative actions have the hurdle where you're speaking for the entire company. So courts want to make sure it's necessary. And the split also affects what evidence you need. So, on the one hand, if you're making a direct claim, you would show how you were misled, your reliance on misstatements, while derivative digs into board decisions and their fiduciary duties. And remember, direct means cash back to you, derivative means cash to the company. So, at the end of this discussion, you could ask a simple question: who's the victim? If the primary victim is the shareholder, it's probably a direct action. It could be that there are lots of shareholders who are similarly situated and you form a class direct action. But if the primary victim is the company, then it's a derivative action. And then the recovery goes back to the company. Standing is the concept in law that you have the right to sue, that you're injured. And in order to have a lawsuit in the corporate context, you have to show what's called injury in fact. Something bad happened that hurt you, and it must be traceable to the defendant's actions. So, in shareholder litigation, we have to show that there is this injury in fact, which comes from some type of harm the company did. So, going back to our direct litigation, how do you show that there is standing to sue? Well, for one thing, you have to own shares at the time there was the wrongful act, and you have to keep owning them throughout the lawsuit. Now, this is key. This means that you can't see that a company acted badly, buy shares, and sue them. And moreover, if you buy shares and then the company acts badly, you have to hold those shares throughout the lawsuit. The idea is it stops people from buying shares after a scandal to sue for profit. Courts would call these professional plaintiffs. You have to own shares at the time of the wrongful act and keep owning them through the lawsuit. Why? It's to stop people from buying shares after a scandal just to sue for profit. Courts call those professional plaintiffs. And under Delaware General Corporation Law, Section 327, this is strictly enforced to keep things fair. For example, if a board's bad decision happened in 2023 and you bought your shares in 2024, you don't have standing. You weren't harmed. It didn't happen when you were occurred. And we would assume that the market priced that bad decision into the stock value that you purchased. You got it cheaper, so you're not hurt. Federal courts follow rules similar from the Model Business Corporations Act. And again, the question is, when did the harm start? Did I own shares then? Do I still? If no, just stop there. The case gets dismissed. This weeds out weak or opportunistic claims. Moving to the derivative suits, again, when the company is harmed and the shareholders are trying to sue on behalf of the company, there's what's called a demand requirement. Before you can sue on a company's behalf, you have to make a formal demand on the board. You have to literally write them a letter asking them to investigate and fix the problem or conduct the lawsuit themselves. Courts prefer companies to self correct, and this is the normal order of things where the directors are the ones who decide what the company does. It's also faster and it respects the board's business judgment. But there is an alternative because if the whole board is in on it, they're not going to go ahead and sue themselves. If demanding the lawsuit would be a waste of time because the board is part of the problem, if you can prove that, you can go straight to court. And this is called demand futility. Demand futility uses the three-part test from the 2021 Zuckerberg case. It asks, did a majority of the directors receive a personal material benefit from the wrongful act? For instance, if the board approved huge bonuses from themselves, despite company losses, they benefited. Asking them to sue over giving themselves bonuses is pointless. They'd say no to protect their money. So the first part of the test is, did a majority of the directors, and again, we're assuming it takes a majority to make a decision, did they receive a personal material benefit? Second question, do the directors face a substantial likelihood of liability if the suit goes forward? This asks if the claim is strong enough that they'd likely lose and pay damages. If that's true, they can't make an objective decision. It's like asking someone to investigate their own crime. Of course, proving substantial likelihood of success on the merits at the pleading stage is difficult, but it's part of the elements of having a derivative claim go forward. And third, do the directors lack independence? This means, are they too close to the wrongdoers? Are they family, longtime friends? Do they go to each other's weddings and each other's children's birthdays parties? Sometimes courts ask these questions because these type of relationships can impact whether or not a director is going to sue a CEO. If the CEO is accused and half the board owes their jobs to the CEO, it may not be independent. And again, this is part of the factors for demand futility. The way to do this process is you analyze each director one by one. If over half fail any part of the three-part test, we can show that there is futility. There's at least one reason that at least half of the board is not going to act objectively in the company's best interests. Here's how to apply the three-part Zuckerberg test. We analyze each director one by one. If any director fails any part, we count them on the side of unable to make an objective decision. And if more than half of the directors are unable to make an objective decision, then the board as a whole is not able to make an objective decision. So, in other words, if over half of the directors fail any part of the three-part test, we can show that there is demand futility. There's no need to ask because the answer would be no, because more than half of the board, meaning enough members to make a decision, are not objective. They have one of these three matters that makes them subject to a subjective personal decision. And again, those three things: did they receive a material personal benefit? Do they face a substantial likelihood of liability? Do they lack independence? If any of those things are true, that director is put in the category of, let's call them conflicted. And if more than half of the directors are conflicted, we don't need to ask them to sue. We can go ahead with demand futility as one of our factual statements in our pleadings. To be clear, this is not easy. Courts make you plead a lot of specifics to avoid vague accusations. So, to make this a little more real, let me try it with a hypothetical. Imagine a board of five directors approves a deal where three get secret stock from the seller. Right away, demand is futile because the majority benefited. You skip the demand requirement and you sue. Another is if the board met and ignored red flags on fraud, like in the Enron case. They'd all face liability for their failure of oversight, their failure of their duty of care. Since all the directors failed their duty of care, if the suit proceeds, and if we can show a substantial likelihood that it would, demand is futile. But if the board is clean and independent, you must demand. And if they say no, that's often the end, unless you can prove some bad faith in their decision making about that. Again, let's contrast this to a direct action. In a direct action, a company claims something like there's no risks in their offering of a new medical device, which, by the way, would be an incredibly stupid thing to do. And if you ever look at some of these IPOs, they're like 40 pages of all the risk factors so that they try to imagine every specific risk, even though it's a little absurd. But imagine that there's a company that says there are no risks in our new medical device, and they hide that it's a defective product that actually causes people to die. You buy based on the filing that this new miracle drug is supposed to cure the world, and it actually kills people. So the stock price goes to zero. You lose money. This is another instance where you don't need demand because you were harmed by a material misstatement, and there's a different avenue for you to pursue this. You can take a direct action on the basis of 10b-5 fraud liability because we have a material misstatement under the Securities Exchange Act. Direct suits often go to federal court for securities rules. Derivative cases usually go to the home state, which is often Delaware in the case of these large public companies. Recent trends like cyber disclosure add some options. So now that there's this SEC rule about cyber disclosure, and if a hack isn't reported, we have some new questions around whether this is direct, like it's misleading, and you have some actionable claim because your own stock was harmed because you bought stock after a cybersecurity incident that wasn't properly disclosed. or you could potentially make a derivative claim. So the lines do get blurry when we have new technologies and new regulations, and that's just one example of how things need to be sorted out. But the general concept that you should take away from today's episode is that you make a direct claim for personal injury, which is usually some type of material misstatement which induced you to purchase stock, or another type of disenfranchisement from the shareholder enterprise. Like if the board moves the shareholder meeting sooner and you can't make it so that you can't actually get to vote for the directors, you might have a direct claim because your rights as a shareholder qua shareholder, were deprived. It may not actually harm the company because those directors might be valuable, but your right to vote was disenfranchised. Again, direct claims are about personal injury, and they're often going to need class actions built around them because many shareholders are harmed in the same way. And if you only own a few hundred shares of stock, it may not be worth it to sue. But if you have a class who collectively own millions of shares of stock, it becomes worth having an expensive litigation. Derivative claims are for company injuries. Standing requires continuous share ownership to ensure real stake, and demand in derivative forces you take internal pathways unless they're futile. And again, we discussed demand futility and its three-part test, which requires benefit, liability, and lack of independence. In our show notes, grab our demand checklist, which has the simple question, did the directors benefit, to help you practice whether or not the suit should be direct or derivative. And in our next episode, we'll explore discovery, the critical phase where you gather evidence to prove your case. Recall that standing and demand set who can access what, so it all should connect. Until then, this is Professor Seth C. Oranburg, and this has been Organized.